Today we're going to do a little more trial time. We are on part 3 of this quite lengthy presentation, and I suspect we'll be going to a part 4 as well. I hope this has been worthwhile, been worth your time thus far. First, we're going to stop by with a little apportionment. This is a fascinating published case, and I think you'll find it very useful. The Gotten case. The doctor apportioned 20% of the permanent disability to DDD. That's degenerative disc disease, of course. And it was held that this was substantial evidence by the District Court of Appeal, although the WCJ and the WCAB said it was not. The reason the DCA said it was substantial evidence was because the doctor relied on an MRI. He had some objective evidence, and he testified that it was accurate to a reasonable medical probability, which, of course, is the standard. This was attacked by the WCJ and WCAB as not being substantial evidence, but because it could not be fully objectively measured. The 20%, there wasn't a study or a test that the doctor could use to objectively verify that 20% of the permanent disability was indeed due to this non-industrial DDD. But the Court of Appeal answered back to that and said the doctor's conclusion cannot be disregarded as speculative when it is based on his expertise in evaluating the significance of these facts. This was a matter of scientific medical knowledge, and the board impermissibly substituted its judgment for that of the medical expert. Subsequent to this case, the WCAB and WCJs have been doing a lot less substituting their beliefs and judgment for that of medical experts. But when you run across that happening, please be sure to refer to the Gotten case. Quote, the doctor made a determination based on his medical expertise of the approximate percentage of PD as required in 4663. This requires absolutely nothing more. So yes, we can apportion to DDD, which is fascinating because who has DDD? Just about everybody over the age of 50. Folks such as myself have DDD. So if you have a back case, and I suspect you have 1 or 2 back cases in your case load, and they've got somebody over the age of 50, you can almost be guaranteed to have an apportionment option with regards to degenerative disc disease. There are citations and studies actually listed in Chapter 15 of the AMA Guides, the spine chapter, some footnotes that actually cite studies supporting the proposition that DDD is suffered by the vast majority of folks over the age of 50. So that's not what I do. Orthos are not allowed to play psych. Psychologists or psychiatrists are not allowed to play orthos. And chiropractors, well, never mind, I won't go there. A medical opinion extended beyond the range of the physician's expertise cannot rise to a higher level than its own inadequate premises. In short, doctor, don't malpractice. Limit the scope of your commentary to your area of expertise. If you try to go outside your expertise, your report is going to be found to be not substantial evidence. And also, doctor, in addition to limiting the scope of your commentary to your medical expertise and not invading that specialty or the expertise of other doctors, you may also not want to pretend that you are a judge. Here's an example. Whether there is an injury, AOE, COE can be a factual / legal question. It is not for the doctors. A report which offers a conclusion as to whether or not a case is compensable intrudes upon a matter which is not a medical question, but is one for the ultimate determination by the judge. So, doctor opinions on such issues are not substantial evidence. Nobody cares whether the doctor thinks the going or coming rule applies, for instance. That's up to the judge. That's up to the evidence that's presented at trial time. Here's a case that was directly on point. The injured worker had a prior hernia and then a subsequent industrial hernia. At least it was allegedly industrial. The QME said, no, the subsequent hernia was not industrial because, well, I don't think the applicant was at work at the time. It was held that this opinion was not substantial evidence. Can you guess why it wasn't substantial evidence? For the reason I just mentioned. That's a judge decision. Whether or not the applicant was away from work is a factual issue. It's it's a factual legal but issue. It is not a medical issue. Whether the all right, evidence not admissible at trial. Opinions based on it are not substantial evidence. You can't go forward to an AME, QME. Medical legals are rejected as untimely. Anything that's written in violation of 4662, any report found stricken or found inadequate by the judge. If these information is sent to the AME or the QME, well, the report may be stricken. So we want to be very careful as to what kind of evidence we forward to the AME, QME. Not only may the resulting report be stricken, but there's an excellent chance that you will be sanctioned for providing inappropriate medical reports to the evaluating physician. All right, let's talk about movies and sub rosa. Be very careful what you allow your investigator to do. This is a famous case. The private investigator pretended he was a friend of the applicant. In fact, became a romantic friend. They partied together, they got drunk together, and they went riding some horses as well. And of course, there was film obtained of that. It was held that this was going to be stricken and it was not substantial evidence. Now you might think film of an applicant riding a horse in violation of work restrictions and in violation of what she claims she can do would be substantial evidence. And indeed, it might have been, but for the fraud. Let's read exactly what the WCAB, actually I take that back, the District Court of Appeals said. Evidence obtained by fraud and deceit in violation of the rights of applicant is not, quote, best calculated to ascertain substantial rights of the parties and carry out justly the spirit and provisions of the workers' compensation laws. The high purposes of compensation law should not be perverted by the resort to evidence perfidiously, love that word, procured. We therefore conclude that the board may not rely upon evidence obtained, as in the present case, by deceitful inducement of the applicant to engage in activities which they would not otherwise have undertaken. Nowadays, I think a lot of people are aware of this and wouldn't engage in this outrageous behavior, but nowadays the more likely troubling activity similar to this would be friending somebody on Facebook, pretending you're somebody else and asking them to allow you to become their friend. This too can get you into this kind of trouble. So, reports here, reports there, reports everywhere. At trial time, we usually have lots and lots of reports. We got PTP reports, we've got AME reports, possibly more than one, QME reports, possibly more than one, and obviously there's a potential for conflict. In fact, it's almost invariable, or it's almost impossible to imagine it there not being conflict. That's for the judge to decide as to which is more appropriate, which is more accurate. And it's not a question of a weighing game. We're not going to, the judge is not going to say, well, I've got 3 reports saying ABC happened and 1 report saying 1, 2, 3 happened, so it must have been ABC. No, it's which reports are more substantial evidence. Specifically, according to 3202.5, when weighing the evidence, the test is not the relative number of the witnesses, or for that matter, the reports, but the relative convincing force of the evidence. So conflicting reports, when the question of whether applicant is a credible witness is different from the question of which physician is the more persuasive one. The latter question does not depend on demeanor, but instead calls for an evaluation of the physician's reasoning processes. Get it right the first time at trial. Why? The WCAB's findings and conclusions, if they are based on substantial evidence, they equal questions of fact that are important to note, conclusive and final. Meaning they're not going to be reviewed by the courts above. The findings and conclusions of the appeals board on questions of fact are conclusive and final and not subject to review. So if you get the facts and figures wrong at trial, you're not going to be able to rely on the District Court of Appeal to save you. As long as there's substantial evidence in the record, you're going to be out of trouble. What does this mean? Actually, they're not going to review conflicting substantial evidence. AMEs. AMEs are mighty powerful. How often do you use AMEs? I hope not terribly often. There are a whole host of reasons not to use AMEs. And as a result, I recommend 99% of the time not using an AME. Going off track a little bit, let's talk about the accuracy of AMEs. The truth of the matter is, if you take AMEs, QMEs, and PTPs and figure out who's more likely to properly apply the AMA guides, it turns out it's the PTPs. And in our Bradford and Barthel's rating and file evaluation service, we've evaluated over 20,000 reports. And it's the numbers are very clear. It is the PTPs who do the best job. Second place, QMEs. Dead last, the doctors whom you rely on, who you wait the longest for, and who you pay the most for, do the worst job properly applying the AMA guides. And if you think about it, it's the AME must split the baby. If you take a look at the AMA guides, if the AME properly applied the AMA guides to all spine cases, 30% of those would be, about a third would be zero, take nothings. If AMEs properly applied the AMA guides to all carpal tunnel cases, over 2/3 would be zero, or take nothings. If the doctors properly applied the hernia chapter of the AMA guides, near 99% of the hernia cases would be zero. Well, can you imagine how many times an applicant's attorney is going to agree that to a doctor as an AME who 1/3 of the time zeroes out back cases, 2/3 of the time zero outs carpal tunnel cases, and it almost always zeroes out hernia cases. It's just not going to happen. So the AME is going to do the work, do a lousy job. And this is just the numbers. I'm not saying this is always going to be the case, but it's going to do the poorest job in terms of properly applying the AMA guides. They're also the most, when they do a bad job, they're the most difficult to contradict because they are your expert. Let's take a look at some of the case law, or some quote from a number of cases on point. We begin by presuming that the AME has been chosen by the parties because of his or her expertise and neutrality. Therefore, his opinion should ordinarily be followed unless there is a good reason to find that opinion persuasive. There is a presumption in favor of the opinion of the AME. They are given great weight and considerable weight. So, in sum and substance, if you disagree with the PTP and you want to render their report not substantial evidence by facts, figures, or doctor deposition, you've got a fair chance. If you want to do the same thing to a QME, you've got a fair chance, because neither of them are your expert. At least they probably aren't your expert. More about that later. But an AME is your expert, and the judge is going to look at you kind of funny when you say, I want to disagree with my expert and render his or her report not substantial evidence. So just say no to AMEs, because this can cause you a great headache. Now, even AMEs can be rejected, but their information has to be pretty, their opinions have to be pretty outrageous. Here's an example. The AMEs in this case said no objectives, and that the applicant didn't need physical therapy because everything was quote unquote normal. And chiropractics weren't needed because everything was quote unquote normal. And surgery was not needed because, you guessed it, everything was quote unquote normal. But nevertheless, the AME awarded the applicant over-the-counter medications. Well, that doesn't make a whole heck of a lot of sense, and it was held that this AME's opinion was not substantial evidence because the over-the-counter opinion was contradicted by the doctor's own report. So it's tough to destroy an AME. They still must follow all the same rules as QMEs. It won't be substantial evidence if known to be erroneous, based on facts no longer germane, based on inadequate medical history, based on inadequate exam, or based on a legal theory, surmise, speculation, or conjecture. However, if any of these applies, the judge is far more likely, in the case of the AME, to give the AME another bite at the apple to correct that report and send the parties back to the AME to get that corrected. Panel presumptions. Remember the old-fashioned PTP presumption of accuracy? If you're an old dog like me, you'll remember what a pain in the neck was what that was. Panel presumptions, there are no similar presumptions for panel QMEs. The opinion of the panel QME is not entitled to a presumption of accuracy. Although the judges sometimes seem to apply one, we need to make sure that they don't do so. Rather, the panel QME's opinion is entitled to no more nor any less weight than the opinion of the treating physician. So if you've got a PTP you like and the opposite side has a QME that they like, it's a fair fight. The PQME's opinion is entitled to no more or less persuasive weight than the opinion of the treating physician. So it goes both ways. The point, if your PTP is substantial evidence and your QME is not, the PTP report is going to win the day. If your PTP report is not substantial evidence and the QME report is substantial evidence, the QME's report is going to rule the day. If neither is substantial evidence, we're going to have to look elsewhere or get supplementals. And if both are substantial evidence, either one of them can win. It's up to the judge as to which report is more substantial than the other. I said earlier that we don't want to deal with AMEs, and we don't want to deal with QME, or we want to deal with QMEs or PTPs because we can't be accused of having them as our expert. But there are times if we agree outright to a QME, we can turn them effectively into an AME. And this is highly problematic. In this case, the parties agreed to PQME with Dr. F. Dr. F was not an AME, but jointly selected by the applicant and jointly and to perform a PQME report and to undergo a deposition. A medical evaluator to which the parties have agreed to submit medical legals has presumably been chosen by the parties because of the evaluator's expertise and neutrality. Does that language look familiar? That's the language we just read about AMEs. Therefore, the opinion of such selected evaluator should be ordinarily followed unless there's good reason to find that opinion unpersuasive. In short, they seem to be spiriting the AME language and arguments into the panel QME scenario. That is entirely inappropriate. And at this point, I can only recommend that when you get a panel QME report, or I strike that, a panel QME list, that when you strike the PQME, your PQME strike, you send a letter to applicant's counsel stating that you disagree with all of the QME offers and you are not agreeing to any of them as an agreed upon PQME. You're simply doing it under protest. It's not a PTP. It's not a PQME. It's not an AME. What is it? There's one other type of doctor out there that we use in workers' compensation here in California. It's a court-appointed IME. Now, an agreed or independent medical examiner. Now, if you look at the hundreds of pages of regulations and labor code here in California, you are no longer going to find the term independent medical examiner. It's just not in there. Nevertheless, those words have been substituted and we have a new name, and it's a regular physician. According to the Labor Code Section 5701, the appeals board may from time to time direct an employee claiming compensation to be examined by a regular physician, a doctor that will be chosen by the WCJ in most cases. When can an IME be assigned? Well, after the trial, if the judge decides that the medical record requires further development, or the supplemental opinions of the previously reporting physicians don't do the job curing the medical record, or the parties cannot agree to an AME. But IME is assigned only, however, if there's no substantial evidence to support the award. If there's any substantial evidence, the judge is going to rely on that and not go down the IME route, which is highly unusual. I've only dealt with IME even the threats by judges to use an IME or a regular physician a few times in the last 25 years. If the IME is substantial, well, strike that. If the IME it is determined is necessary because any of the other existing evidence is not substantial, it will be followed. Now, more often than not, as I just suggested, the IME is threatened by the judge, but the threat doesn't go through. The reason the judge will threaten an IME is to simply, among other things, to get the parties to really work on settling. Why? Well, nobody wants to face the cost, time, or money of further discovery. Getting an assigned doctor by the judge is kind of a crapshoot. You have no idea whether they're going to be liberal, conservative, or straight shooter. And they're going to be like an AME because the judge is going to, as the judge having assigned them already, we know, believes that they're neutral and should be followed. Similarly, the judge will often use the threat of the IME to get the parties to agree to an AME. Of course, something that I disagree with. I said earlier that 99% of the time I recommend against using an AME. This would be one of those situations where I would consider using an AME because at least with the AME I have some control over who we're going to select, whereas if we go to an IME, this is going to be completely decided by the judge, and I don't want to leave that much power in the judge's hands. Now, if there's no substantial evidence at all, and the applicant has failed to prove their claim, wouldn't you think that the applicant simply loses? It's their job to go forward and prove their claim. They have the initial burden. Shouldn't we be getting to take nothing as opposed to a regular physician being assigned? I think the answer is yes, but oftentimes that's not what happens. The threat of a regular physician is made. I think this is something you want to ask and challenge, ask about with the judge and challenge the decision to, or the suggestion that an IME should be given as opposed to a take nothing. Range of evidence. The general rule is the doctor decides to follow A, they must follow all of Dr. A's findings. Sorry about that. Let me restate that because I'm stuttering. If the judge decides to follow Dr. A, he or she must give full weight to Dr. A's findings. Quote, it is well settled at the board if it relies at all on the report and testimony of a medical examiner to give full weight to all of the findings of that doctor and may not omit a factor of disability described by him. An award which ignores such factors lacks substantial evidence to support it. Now, this is only a general rule. There are times that this is not going to occur and that the judge can actually rely on a range of evidence. When the commission or the WCJ or the WCAB is confronted with widely divergent views as to the extent of the loss of function of a body, they may make a determination within the range of evidence as to the degree of disability. The judge may accept the evidence of any one expert or choose a figure between them based upon all the evidence. So it's most often used, this range of evidence theory is most often used when the permanent disability reports appear to be equally valid. Now, this was a much bigger issue back prior to 1105 when we're not using the AMA guides. Additionally, picking and choosing parts of different reports for different issues, can that be done? Absolutely, it can. There was a case recently, the AMA, it was a post-1105 case anyway. There was an AMA-based PD award using the PQME's report regarding the back and the PTP's report regarding the permanent disability of the knees. This was found to be okay. So stipulated. We're going to talk about stipulations for the next 10 minutes. Stipulations can be very valuable and very problematic. If you can't agree to everything, we can settle or go to trial. If we can agree to something, we can use stipulations. Now, I know you're familiar with stipulations in some venues, but let's go over all of the places that we can stipulate things. some of the advantages to stipulations. They expedite the process. I agree, you agree, let's put that issue to one side so we don't have to have the judge or a doctor decide it. And it's going to make the judge a lot happier. If you come to the judge and he or she asks, what facts and figures can you two agree to? And the answer is absolutely nothing. I think the judge is probably going to be a little upset and send you away and say, well, you go down into the other room and hammer out what you can agree to, because I don't want to have to decide every single issue in this case. The negative part of stipulations is that's it. You're stuck with it. In almost every case, you're not going to be able to get out of that stipulation, even if later on you decide that it was a bad thing to have done. CCR 10496 provides that awards and orders may be based upon stipulations of parties in open court or in front of the judge, or upon written stipulations signed by the parties. No findings may be made contrary to the stipulations of parties on an issue without giving the parties notice and an opportunity to present evidence, and and the parties provide some really darn good evidence. In short, awards can be based partially or totally on stips, and the WCAB won't arbitrarily reject them. What are we talking about? Stips are an agreement between opposing counsel, ordinarily entered into for the purpose of avoiding delay, trouble, or expense in the conduct of the action. As I suggested earlier, they narrow down the number of issues that the judge has to decide. Quote, a stipulation may lawfully include or limit issues or defenses to be tried, whether or not issues or defenses are pleaded. So, enter into a stipulation. It is treated as a fact. We're going to ignore trial evidence to the contrary. The pleading shall be deemed amended to conform with the stipulations and statement of issues agreed to by the parties. So, stipulations dictate the facts. Wait a minute. Stipulations dictate the facts? Don't the facts dictate the facts? No. The facts will not dictate the stipulations. Once you've stipulated to a fact, you can stipulate to the sky being green. If you've stipulated the sky being green and you look outside and everybody would think that the sky is blue, the fact of the matter is now, for the purposes of this case, the sky is green. Why? Well, that's a whole reason to have stipulations, so we can get that issue off the table and move on to more important issues for which there is a conflict. Stipulations are going to bind the parties, but not the judge. The judge can do things with them. The parties to a controversy may stipulate to facts relative thereto. The board may thereupon make its findings and award based upon such stipulations, or decide that that's not sufficient and make further investigation necessary to enable it to determine the matter at hand. How does the WCAB reject the stipulation? They find good cause. But what's good cause is the obvious question. The proof that a stipulation has been entered into through inadvertence, excusable neglect, virtually never seen, fraud, highly unlikely, mistake of fact or law, or where there's been a significant change in the underlying conditions that could not have been possibly anticipated. Now, it sounds like there's a whole lot of ways to find good cause and have the stipulation rejected or undercut. The truth of the matter is these almost never happen. See, for example, if the stip is entered into through mistake. What's a mistake? It's got to be mutual, and that's the big problem. Oftentimes, one party or the other will enter into a stipulation and later on say, oops, we were wrong. We stipulated that we have a PDA credit of $10,000, and now we determine the PDA credit should be $20,000. Well, we can stipulate on the folks who pay for it. The defense are going to stipulate to that, but there's no chance that applicant is going to stipulate that that was a mistake. Stipulation is not justified by the evidence, leading to a bad unintended result. Tough luck. Stipulation doesn't comport with conflicting medical opinion. stipulated without exercising due diligence, you guessed it, tough luck, buddy. Stipulations based on miscommunication between the employer and the defense attorney, altogether now, tough luck, buddy. Here's a weird one, however. Imagine this happens to you. Now, please hope you don't. You and applicant's counsel stipulate to AOE-COE. I hate stipulating to AOE-COE. And in exchange for this, it's agreed that we're going to use Dr. AME. This is not you, because you're not going to go to an AME 99% of the time, remember. But you stipulate to going to Dr. A for AME for TD, PD, and treatment. And as a result, discovery remains closed. The STIPs are approved. So now you've got an agreement. But applicant's counsel reneges and says, and comes back and says to the judge, the parties have been unable to proceed with an AME examination. We want to handle this another way. You simply say, hey, wait a minute. If it's good for you, it's good for me, then we're going to renege on the stipulation of AOE-COE. I want to withdraw. What happens? You're stuck. Tough luck. Consistent with, well, defendant can only withdraw from these stipulations on a showing of good cause. Such a showing has not been made. Defendant alleges that the stipulations were contingent on the applicant submitting to the AME. This contingency is not apparent from the plain language of the stipulation. So they may not agree, they may not follow through on the stipulations, but that doesn't give you a way out. So what's the lesson? You need to use if-then language in your stipulations. They need to be drawn up very carefully. If applicant agrees to and attends an AME for the issues of 1, 2, and 3, then the defense agrees to agrees on the issue of AOE-COE. Definitely use this if-then language. I very rarely see this language in stipulations being drawn up at the board. Make sure your attorney or hearing representative is using this language. And of course, if the if happens, if applicant, for example, refuses to go to the AME, take action immediately. Petition to compel the participation in the AME examination forever. We don't want the WCAB to say you waited too long and you've waived that issue. What about this situation? You stipulated to A, B, and C based upon your understanding of the law as it's written, and shortly thereafter, the law is rewritten. You got a get out of jail free card in that situation. It doesn't happen very often, but when you stipulate to the law and it's clarified or changed, more importantly, by the legislature, that's going to undo the stipulation. What's not good cause for getting out of a stipulation? Having assessed the likelihood of a decision in their favor and the accompanying risk of the decision against them, parties to a work comp proceeding, as in other cases, may settle a case accepting less than they want in order to limit the risk of receiving even less or nothing at all. In short, you stipulate to an award, and then later you decide, wait a minute, I could have done better. Tough luck that you've entered in the stipulation. You're going to be stuck with it. What if you can't read the thing? I got terrible handwriting, or it just doesn't make sense. You can read it, and it makes no sense at all. When the terms of a stipulation agreement are unclear or ambiguous, there's nothing for the judge to approve. If the judge can't see what was happening, what was agreed to, how can they possibly enforce it? So what are our stipulation options? There's lots of stipulation options. Stipulations with request for award. I'm sure you're all familiar with those. Stipulations in the pre-trial conference statements. Pretty sure you've seen those. Stipulations in open court. Those of you who are not lawyers may have not been aware of these. Stips at deposition. You're all probably familiar with those. Written agreements out of court. Those letters that go back and forth between the parties. Those can be stipulations as well. You may not have been aware of that. So let's go with those in order. Stipulations with request for awards. If you can agree, obviously, to resolve the claim or part of the claim, you sign the stipulation, you submit to the judge for an award. If found adequate, and it's more likely to be found adequate if there's representation as opposed to a pro per, the award will issue. What if you've submitted it, you sign the stipulation, you've submitted it, no award is issued, and then you realize, wait a minute, there's a mistake, or it was a bad idea, I am reconsidering this thing. Judge, you haven't taken action, I'd like to withdraw from the stipulation. Tough luck. If a party could, as a matter of right, withdraw from a stipulation any time before it was acted on by the judge, other parties could not rely on the stipulation, and rather than being expedited, hearings would be subject to uncertainty and disruption. So be very careful when you enter into a stipulation. It's going to be virtually impossible to withdraw it, even though the judge hasn't taken action. What about when the stip has been awarded? Now jurisdiction changes. It can't be changed. The stip can't be awarded changed greater than 5 years post-injury, of course. Stipulations in a pre-trial conference statement. Of course, we often refer to this as the stip and issues. These are not judge orders. They are simply read into the record come trial time in open court. They can also occur throughout trial, memorialized in the minutes of the hearing, and they are considered a formal agreement. Oftentimes this will occur when you're cross-examining, when there's cross-examination and the judge gets the point and everybody seems to be nodding, and the judge will simply say, can we all agree to X, Y, and Z? And everybody in unison says so stipulated, and then we can proceed to other issues. Stipulations in open court need magic words. After the parties stipulate, the judge has to say it is hereby so ordered, or it is hereby so awarded. This will transform the agreement made by the parties in open court into an actual order. And that's important because to give enforcement to the stipulation, it must be treated as if it is a formal finding and award issued by the judge. If there are no such magic words, there is no order, there is no stipulation. For example, the employer stipulated into, I should not say there is a stipulation, but there is no order. In this fact pattern, the employer stipulated in the minutes to an increased TD rate and then didn't pay it, which is always a bad idea. Applicants sought penalties, and it was held that the penalty for 5814 was awarded, but not the 5814.5. Can you guess why? Well, we just mentioned it. Well, the stipulation was enforceable, the magic words had not been said, and it was not transformed into a benefit award. All right, what's the difference between the stipulations and informal agreements? Informal agreements are made all the time, and usually not even translated or put down into writing, because oftentimes the parties know each other and they trust one another. It's generally recognized by the WCAB that stipulations are to be encouraged. Agreements by the parties that was not set forth in an order is an informal agreement and not an enforceable order. But what about stipulations at the deposition, on the record? Oftentimes we see stipulations on 5710 fees, and those will be enforced. I refuse, and at deposition time, to stipulate to anything in terms of 5710 fees, because I don't want to speak out of turn, and it's going to be up to my client as to how we proceed with 5710 fees. Written agreements outside of court, no order, no minutes of hearing, just letters, emails, and text. Can that be enforced as a stipulation? Is it enforceable? Believe it or not, yes. Be careful what you write to applicant's counsel or to the applicant. Parties to a controversy may stipulate to the facts in writing and file such a stipulation with the appeals board. Orders and awards may be based upon stipulation of the parties in open court or agreed written stipulation signed by the parties. So, writing drafted at court versus outside of court, there is no difference. So if you write it down at the applicant's counsel's office and you write it down in front of the judge, they're both enforceable. Stipulations can waive your defenses. This was an interesting case. The employer said, all right, we will pay for home health care at $12 an hour. And it was held that that was that was enforceable, even though there's another way of determining the rate. We have labor codes that help us determine the rate of home health care. It was found that this stipulation superseded the labor code. Here's another example. They'll strike that. The enforceable agreement must be a true agreement. It must be a meeting of the mind. Here's one that will make you feel a little bit more comfortable, hopefully. Those permanent disability notices that we have to issue. In this case, the employer issued a PD notice estimating PD at 30%, and this was based on the PTP report. Unfortunately, this was around 2005, and the employer used the wrong permanent disability rating schedule. Apparently, they used the old permanent 1997 schedule instead of the 2005 schedule. And applicant's counsel said, well, wait a minute. You stipulated a 30% PD. That's enforceable. I want my 30%. It was held, no. It was not an offer. It was a notice, because Labor Code Section 4061 requires a notice, a quote, notice, end quote, not an offer. Oral agreements outside of court. We've already suggested that these can be enforceable, but they have to be extraordinary. Absent extraordinary circumstances, any agreement to be enforced in workers' compensation proceedings must be reduced in writing, so they can show that there's a true meeting of minds. Otherwise, it says here, we'll avoid unnecessary confusion in litigation. Think about it. If you put something into writing, the judge knows what the agreement is, or can interpret the agreement and enforce it. If the parties have simply orally agreed to something, there's nothing for the judge to look at except the representations of the parties, and it's going to be very difficult for the judge to decide. And you're not going to swear in applicant's counsel and defense counsel to give testimony as to what the oral agreement was. So this is just going to cause more trouble than it's worth. Stipulations are there to narrow down the issues, not to add additional issues. So oral agreements may be valid, but they're so tough to define that they're going to be deemed unenforceable. Oral agreements can be binding if, however, there is writing later on. If the confirmation is sent within 5 days after the agreement is formed, and there's no objection within 3 days of receiving the confirmation. So when you've reduced the agreement, or you've got an agreement to settle, or an agreement to do something else, and you're really happy with that agreement, write to applicant's counsel repeating the agreement, and wait for 3 days and see if you get a response. Otherwise, you will have yourself and if there is no response to the negative, you will have a stipulation, a binding stipulation. What kind of stipulations are never going to be enforced? Those that are contrary to law, those are contrary to court rules, those that are contrary to public policy. And here's an example. There was a stipulation to reserve jurisdiction beyond the 5-year limit. And that was held unenforceable because the board never had that jurisdiction anyway. It can't enforce, and the parties can't stipulate the jurisdiction that the WCAB never had in the first place. Here's another fact pattern that should scare you defendants out there. The Bertrand Decision. There was a stipulation to resolve future medical issues via an AME. This is an agreement that parties agreed to for years in stipulations and awards. Of course, later on, we got UR and IMR, which has been created to be the exclusive means by which to resolve medical issues. It was held what was it held? What do you think? Are we going to use UR-IMR, the legislatively dictated way of resolving medical issues, or are we going to follow the stipulation? Turns out we're going to follow the stipulation. So who's trapped in the stipulations web? Who has an attorney who has the authority? A party that the party rep by the attorney is bound. If the attorney has the authority, the party is represented by the attorney is bound by the stipulation. However, what if the stipulation is unauthorized and the stipulation is made without knowledge of the client, or the stipulation is made without the consent of the client? At that point, it's not going to be enforceable. It's going to be a nasty fight between the client and the applicant and the attorney, rather. But if that nasty fight proceeds, the party may be able to get out of the stipulation to which the attorney attempted to bind them. What if there's not enough? I'm going to read this very quickly. Due process dictates that stipulating parties always must be given notice and opportunity to present evidence on a material fact covered by the stipulation before it is disregarded. But a litigant who does not sign a stipulation is not a party to the contract, and he is not shielded automatically by the due process clause. A party who has not signed a stipulation has standing to complain if the stipulation is subsequently rejected by the referee in light of all the evidence, and if he relied upon it to his deference. As to non-stipulating parties, actual reliance on the stipulation is the essential ingredient to a successful claim of lack of due process. All right, what if we've gone through the hearing and the judge feels that there is not sufficient evidence? They can go out and get more. Discovery shall discovery is supposed to close on after the MSC, and we're not supposed to get more admissible evidence unless it can be demonstrated that the evidence that was trying to be presented, the subsequently obtained evidence, was not available or could not have been discovered through the exercise of due diligence prior to the MSC. So, what's the point? You fail to disclose information or evidence or witnesses at the MSC, it's going to be inadmissible. Fail to timely locate the information, it's going to be inadmissible, short of a showing that it was not otherwise available or would not have been available through the exercise of due diligence. You can lose on this argument even if the evidence didn't exist prior to the MSC. Well, wait a minute. The evidence didn't exist prior to the MSC? How could I have possibly listed it at the MSC time if it didn't exist? Well, it is possible. Imagine you obtain post-MSC medical. That could be held inadmissible. You obtain post-MSC video. That can be found to be inadmissible. You got to show that it was not available and why it wasn't available and why due diligence wouldn't have helped. So, for example, you obtain film of the applicant riding that horse, even though they claim they can't sit, and that horse riding is obtained the day after the MSC. You're going to have to prove that there was no way that you tried to obtain that evidence and made the good college effort to obtain such evidence prior to the MSC and it wasn't available. If post-MSC was the first time you conducted sub rosa, you're almost guaranteed to be out of luck in terms of getting that sub rosa into evidence. So what's the upshot? Get the evidence prior to the MSC. If you've got a major case and you're going to do sub rosa, and I assume you're going to do sub rosa in any suspicious lifetime pension kind of cases, start getting that film as early as possible. Now, is there a way of getting out of this problem? That is, you didn't have the evidence at the time of the MSC or didn't list it. Well, there are some escape options. You may convince the other side to stipulate to the admission of MSC, of evidence obtained post MSC. there may be a reason they want to stipulate to that. They may want something from you. Another possible escape hatch is the failure to timely object by not objecting to the evidence submitted post-MSC. So I've seen it happen many a time at trial, for example. One party or the other offers up evidence, offers a document or testimony into evidence that wasn't listed at the MSC, but the opposition just fails to catch it. Well, if they fail to object, all bets are off and the information will go in. One other escape hatch, the judge approves keeping discovery open post-MSC. And oftentimes that will occur if you can give the judge good reason, or oftentimes instead of keeping the thing on calendar, they'll take it off calendar and allow the parties to continue with discovery. Typically, they'll simply write on the minute order, discovery incomplete, or discovery needs to be continued. A last escape hatch, there's surprise evidence introduced by the opposition. Suddenly, for example, at the time of the MSC, a voc rehab report is presented, and there's no evidence that by applicant's counsel, and there's no evidence that the defense was ever informed that there was going to be a voc rehab study done on applicant's behalf. Invariably, the judge will keep discovery open post-MSC or take the matter off calendar. Tailored discovery closure order. Discovery closed except for specified information. This can happen when the party is not diligent regarding specific information. There's a possible exception, pro pers. WCAB, denying defendant's petition for removal, affirm the judge's order for reopening discovery on the day of trial to allow a pro per to complete her exhibit list when the WCAB found she was unrepresented, hence the pro per. She was ignorant of what the MSC was and consequently failed to attend the conference and did not have the opportunity to participate in the pretrial conference statement and had a fundamental misunderstanding of the trial process. Now, I hate this case. What did they say about somebody who has themselves as somebody who representing themselves having a fool as a client? Pro pers are always entitled to get an attorney. The judges will often recommend that they get an attorney. Here the pro per didn't and then didn't pay the price. Highly questionable decision. The closing of discovery versus the authority to develop the record. 5701 is something that we really need to read. The appeals board may cause testimony to be taken or inspection of premises or time books or payroll of the employer to be examined by a member of the WCAB or somebody appointed by the appeals board. The appeals board may also from time to time directing the employee claiming compensation to be examined by that regular physician that we talked about. Upon filing of a petition for reconsideration or having been granted a reconsideration on its motion, the WCAB may grant reconsideration and direct the taking of additional evidence. So, applicant's expert witness was viewed sub rosa. The employers had not. It was remanded for further development. Medical evidence as to the nature of extent is lacking. The WCAJ was free to reject the opinions of the employee's doctors, which included consideration of surveillance films. However, in order to ensure reliance on substantial evidence and a complete adjudication of the issues consistent with due process, it was necessary for the judge or the WCAB to facilitate review of this critical information by the doctors or employ some other reasonable and fair method of considering the circumstances of awarding benefits based on the medical opinions lacking crucial information violates the employer's due process right. So what's the uptake of this? Apparently there are some times that the employer's argument that they're entitled to due process will actually succeed. Now, we've got a bit more to go over, and we will be going over that next month, including problems at trial time. I look forward to reviewing that with you. I apologize that we've gone over. Let me put you back with Tammy, and once again, happy Valentine's Day to everybody.